It is more important than ever now to make sure that your summons and petition are correct when you file, because it is now the end of the game if they are incorrect. And I've talked about the fact that if your summons and petition are incorrect, that it will cause your judgment to be rejected. And I tell you how the summons and petition and all documents you file prior to your judgment do not get reviewed by the court until you turn in the judgment. When you turn in your judgment package, that's what triggers a full audit of your file. I know there's people out there who don't believe me. They say, Tim, that's not true. Why do they file my form if why do they file it if there's something wrong with it? They do. They don't care. It doesn't, no review happens to your divorce case until you turn in your judgment. That's the trigger. So what happened in this particular case is clients had started their own divorce before hiring me. We turned in their final paperwork, and what she provided me as far as her paperwork was not what she actually filed. She provided me documents that she had typed up, and then as a result, what it turned out to be is she had filed documents she had prepared by hand and did not put her address on the summons. So when I turned in a judgment, everything that she presented to me seemed accurate. So when we turned in the judgment, we got a reject, and they said, "Oh, the summons doesn't have an address." I said, "Well, that's not a copy of the summons that the client provided me." So what she provided me and what was filed were two different things. Unfortunately, the default had gotten entered. The default was entered, and now, and this is new, the court is requiring that a hearing be set to set aside the default. All this time, last 11, 12 years I've been doing this, if the petitioner files a default, requesting our default, it's entered, and then there's an issue on the petition, for some reason we need to amend it, all we do is amend the summons and petition, and it automatically sets aside the default. And then we move forward, and then we file a new default when we go to do the judgment package. I know this is a lot. Hang on there. Hang in there. Now the court is saying no. So what happened is we filed an amended summons petition like we always do, and the court rejected it, saying you need to set a hearing to set aside the default before you can file your amended summons and petition. This is so crazy. Never seen this happen. You know, I've worked for the courts in the past. Just goes to show you how it can be different between courthouses, counties, and even courtrooms within the same court. So it's just, we have to roll with the punches. Weird things happen all the time, and I have to call the client and say, hey, we need to file a set aside. What we're going to try and do, and here's the issue with the set aside. It's not a big deal. You file for a hearing. Now they have to go attend a hearing, whether it's in person or over the phone. Still, it's a big pain in the butt. 45 to 60 days out is when they're going to have that hearing. So huge delay. Check this out. 2 months to get the hearing. Then we file the amended petition. Then we have to wait another 30 days to submit the default judgment package. Again, that just had 3 months in time because they did not do the petition and summons rights